I'd like to introduce Bill Hicks. He's from the administrative office. He's the pretrial administrator. And we welcome him. We also welcome Sarah Valdez Hopper, the probation officer specialist in the campus. That's about all Bill wanted me to introduce him for. So I'm going to turn the time over to him, and he said he'd give an introduction and introduce Sarah as well. So thank you for coming.
Good afternoon, everyone. So I'm Bill Hicks. I'm the administrator of Pretrial Services from the Probation Pretrial Services Office. A little bit about me. My background is I started as a part-time, temporary Pretrial Services Officer Assistant. Maybe the longest title ever. Started in Virginia Eastern back in 1998. From there, we were consolidated and rose to a probation supervisor, where I supervised a pretrial investigation unit, pretrial supervision unit, some pre's, but mostly location monitoring with sex offenders and pretrial and post-probation. So I'm asked a lot, what is the DROP program? It's the Detention Reduction Outreach Program. It's finding ways to reduce unnecessary detention. Now mind you, I don't say increase release rates. I'm not going to come in and say you need to increase release rates. If that's the case, we just say let everybody out. You know that's not possible, right? My goal is to bring all the stakeholders together in a collaborative effort to understand what it is we do here in pretrial services probation with the picture, and take a look at our stats and have a discussion. This is the first district in the country to utilize picture in the bail report. And I know some of you have seen it. You may not know what the background is. We're going to do some of that today. And I also hope to have a discussion about picture. What it is you think is good? What don't you think is good? That way I come out from it and take it back. We're in the process of revalidating the risk assessment tool now to include violence, because it's something I wanted. But I also, when I go to these drop visits, it's something that I think is important that I hear from each of you about your concerns, about what you like about it, about what you think we could improve on it, things like that. So I can go back and then I can use that when I'm researching the better tool. So as we move forward today, we don't have a lot of time. This is an abbreviated drop visit. Generally speaking, I do 2 days to sometimes a week. I work with pretrial or probation office on certain issues. We work with the court on certain issues, whatever it may be. It's about the processes. So in this presentation, it doesn't work if we don't have discussion. So as we're going through this, please don't sit there and walk away from here and say, I hate the tool, and you never had a chance to ask me, or even tell me you hate it. That's fine. I'll tell you a story. I hated picture. Absolutely hated it. While I was in the Eastern District of Virginia, I've been doing bail investigations over a decade. It's 15 years. And what I said when they released it was, who in the world is the AO to come in here and tell me how to do my job? I know what I'm doing. I've been doing it forever. I'm all about releasing the right people. So my goal was to debunk picture. And I worked and I fought with Tim Cadigan, and that's probably why I never got a chance to go to the AO ever till I was hired. Because right there from Richmond, Virginia, I fought with Tim Cadigan on just about everything, trying to debunk this picture. The more I looked at picture, and the more I applied it in an effort to debunk it, the more I saw that it had some value. It is not the main thing. You are going to hear me say that, you're going to hear Sarah say that today. It is not the main thing, and nor will I come in and try to preach that to you. But it does have some value. It does need some work. That's why we're revalidating. I hope you hear that today. So I'm not here to push picture on you. The only thing we want to do is be able to make sure you understand what the risk assessment tool is, what its purpose is, a little bit of background about that, and then we're going to get into your stats. we're going to look at your release rates. We're going to look at what type of cases you have. We're going to look at recommendations. We're going to look at violations. And then we may have some discussions about that to see if there's anywhere we could target for reducing unnecessary detention. It may be that I walk out here today and we say right now that's not the case. That may be possible. But at the very least, it's the first time we're all together to discuss this, and my hope is that you would have continued discussions. One thing I've noticed as I've gone across the country, and I've done about a little over a dozen of these across the country, is that when you bring people together, it sparks an understanding of our roles and our mission. But maybe before, you may have the U.S. attorney telling the officer, what in the world are you recommending release for? Do you know this guy is this, this, and this? Why don't you consider the presumption? Why don't you consider the weight of the evidence? Things they can't do. It may be the federal defender's office saying, why don't you release this guy? He has a place to go. I'm hoping that from this discussion, we spark additional discussion and that we continue a collaborative effort to reduce pretrial detention. With me today, I have Sarah Valdez-Harper. Sarah is from the District of Kansas. She's a specialist in the District of Kansas. They were my second drop visit. Since they started doing drop, and they started utilizing the picture in the bail report, the District of Kansas reduced unnecessary detention. I said I wasn't going to say it, I did it all right now. No. They reduced unnecessary detention by double digits. That's not the only thing. I can't say just reduce unnecessary detention. I need to know what are your outcomes. And there's been no change to their rearrest, no change to the failure to appear. Nationally, we're starting to see an uptick in pretrial release when you look at it as its whole, where it's actually increasing. In fact, I just looked at the data, and it increased by 1% within the last 12 months. But when you added in illegal aliens, it increased by 1.3%. Blew my mind. Because I've always said that, what do we always say? Illegal aliens never get out. So things are changing. I think there's a way to find the right people, but I think it starts with these discussions. And so with that, I'm going to introduce Sarah. Sarah's going to start with the picture. I'm going to try to sit down and let her do this because she's a great presenter, but I will be jumping up and kind of pinpointing certain things because I can't sit down. All right, thank you. Maybe it's too early to call for me.
Good afternoon. Thank you for having me. Like Bill said, I'm Sarah Valdez-Harper. I'm a senior officer in the District of Kansas. I've been an officer for a little over 10 years, always specializing in pretrial. And we were the second district in the nation to host the drop visit. And it was just a fabulous experience for us. So it's a real honor to be able to come with Bill to other districts and to share that experience with you all. So thank you for having me. When we hosted the drop visit in Kansas, we were actually first in the nation on Petra timeliness, and we'll look at some of that when we get into statistics and a little later on the Petra, and that is getting it completed at the proper time. So, but what we walked away from the drop visit realizing was we were completing the Petra, but we weren't really using it effectively. We probably didn't understand exactly how it was intended to be used, and we walked away from the program understanding how we could better apply that. We started incorporating it into our discussions, really recognizing how that tool would help us make better recommendations for the court. So I always look forward to being able to come and share that information with other districts. Today we're going to start talking about the Petra. And our starting point is kind of like Bill said, this is the DROP program. It's the to reduce unnecessary detention is the goal. And so there's recent studies, a lot of research that has come out that talks about the field of pretrial. And so I wanted to start off just sharing some research that's been done recently in Kentucky as a starting point. So the Laura and John Arnold Foundation, that's a foundation that specializes in research in different areas, and they propose problem-solving approaches And pretrial has really gotten their attention over the years. So in 2013, they released some findings of research that they conducted in Kentucky that looked at the effects of pretrial detention. So first, they looked at the likelihood of the link between pretrial detention and the likelihood to commit new crimes or to fail to appear. The question they were trying to answer is if pretrial detention could be actually helping create new repeat offenders. So they looked overall at 153,000 defendants that were booked into the Kentucky jail between 2009 and 2010. And what they overall showed was that low-risk defendants who are detained for more than 24 hours are more likely to commit new crimes. And that's not only while the case is pending, but for years further down the road. They're also more likely to miss their day in court. So the study is broken into two parts. And the first part explored the length of time between the time spent in pretrial detention and the commission of new criminal activity or failure to appear. So this part of the study, they looked at 66,014 cases where defendants were released at some point prior to trial. And what they found was that even small increases in detention correlate with worse pretrial outcomes. The study found that when held for 2 to 3 days, low-risk defendants are 40% more likely to commit new crimes before trial than equal defendants held for no more than 24 hours. It also showed that that correlation escalates as the amount of time detained increases. So low-risk defendants who are detained for 31 days or more offended 74% more frequently than equal defendants within 24 hours. Now, the study, when they looked at high-risk defendants, there was no relationship between pretrial detention and increased criminal activity. However, the same pattern emerged when they looked at failure to appear. Low-risk defendants that were held 2 to 3 days were 22% more likely to fail to appear than similar defendants held for less than 24 hours. And when I say similar defendants, I mean in criminal history, background information, demographics. The number on failure to appear actually jumps to 41% for low-risk defendants held 15 to 30 days, and then it's 31% increase for those held more than 30 days. Detention was found to have no impact on high-risk defendants, on their rate of missing court, and it had a moderate effect minimal effect on moderate defendants. The next part of the study looked at the pretrial detention and long-term recidivism. And what that showed was the longer a low-risk defendant is detained before trial, the more likely he or she is to commit a new crime within 2 years of case disposition. So compared to defendants released within 24 hours of arrest, low-risk defendants held 2 to 3 days were 17% more likely to commit another crime. And those held for 4 to 7 days were 35% more likely to commit a new crime. Overall, what this study showed was that effectively distinguishing between low, moderate, and high-risk defendants at the pretrial stage can enhance community safety. So that leads us to the history and the development of the Pretrial.
I just want to ask about the first slide where they talk about these low-risk defendants and its effects. Why do we think that is? Anybody knows? Why would it have people like the first slide? So, why is that?
Generally, you go more than just a few hours. It's definitely more than a day. Someone that has a stable job or that employer may not be as likely to hold on to that job for them. If someone isn't sure that they're coming back to work, and then that could be a problem right there as well.
So, I ask this sometimes when I'm working with the officers, because they deal a lot more with the interviews and things like that. Generally speaking, do you see our ones and twos, even though we don't have as many property or white collar cases, but our ones and twos, our defendants in general, don't have stable jobs like we do. Would you say that's correct? Like in terms of, they don't have jobs where they could take a week off just like that. A lot of them have jobs where they may, if they are arrested and they're held for 3 days, they may lose the job and they can't get it back. It doesn't necessarily, I'm not saying causation, I'm just throwing out an example of some of the things that could happen and things that I've seen where they lose the job, the next thing, what do? They can't afford the rent. We spend a lot of time working with these defendants trying to get them jobs. And it's difficult. And so when they have the opportunity to have an initial appearance and have the bond hearing and the decision made at the initial appearance is very important. It's very important because it could have such adverse effects on, and even long term. We're studying it now. I'm seeing some results that are similar to this. I'm not seeing everything exactly like the Kentucky study. Dr. Lowenkamp was at the John Arnold Foundation. He's the one that's doing the study. Dr. Lowenkamp is the one who has developed the Pretrial. But we're seeing some similar results on this, especially in terms of long-term recidivism. Those defendants who were released pre-trial seem to do a little better than those who were detained. Yes?
In terms of that long-term recidivism, what other factors are you controlling for that might contribute to that aside from deciding that
So we can control for, and we're in the middle of this now, so the Kentucky study, they control for, I think they control for the similarities and characteristics, not as much like each charge or, because you're talking 153,000 in the state cases. What we would control for is your picture category, types of charges, things like that, to say, I want to take out as much as I can to make these people look very simple. And then we look at them. So we would control for your charges. Not necessarily your sentence, per se, but we can't control for that. It depends on how we're looking at it now. We're just beginning that, but if you look at it just on its face value, we are seeing it. But you're right. We'll have to go to a detailed study, and that takes years. It's not something that's going to be, Bill Hicks just started this year, and I'm coming out and telling you, this works. I can't say that.
It just seems to me there are a lot of things that contribute to long-term recidivism.
Absolutely.
And that in this case, being detained is probably lower down the risk list.
Well, and that could, and you're very well right, it's services. What services are provided in BOP. We look at that. We look at how their adjustment was in the BOP, things like that. A lot of things could. That's why you're not hearing me say causation. I'm not trying to say that at all. We're just saying at this point we can say there's some sort of correlation.
So in 2009, the OFDT, the Office of Federal Detention Trustee, with the support of the Administrative Office, sponsored research that resulted in a report. The purpose of the study was to identify statistically significant information relevant to predictors for pretrial outcomes in order to identify defendants best suited for release. The independent measures were demographics, offense details, criminal history, substance use information, mental health information, and residential, educational, and employment status. And the dependent measures were failure to appear and new criminal arrest, and then failure to appear, new criminal arrest, and technical violations that led to revocation. The status set that they looked at were all people that were charged in federal courts between 2001 and 2007. It included all federal districts except for the District of Columbia, and that resulted in 565 178 records being looked at. Now, after they reduced that number by those cases that were detained and then those cases that were missing data, the final sample size was 215, 338 cases. So here you can see what the data they looked at, the highlights of that. And as you can see, is during that period between 2001 and 2007, our detention rate was increasing, our release rates were decreasing. You can see the types of crimes that the defendants they looked at were charged with. And we often have ideas that certain crimes are only detained, but you can see we were really releasing defendants in each of those types of crimes, including violence, firearms, theft, immigration, and drugs. Immigration we were not releasing very many. This is their citizenship status, and again, most illegal aliens were being detained. The results were that 9 factors were determined to be statistically significant predictors of pretrial risk. Pending charges, defendants who had 1 or more misdemeanor or felony charge pending were 20% more likely to fail pending trial when compared to those who did not have a pending charge. Prior misdemeanor arrests, defendants with prior misdemeanor arrests were more likely to fail when compared to those with no prior misdemeanor arrests. Prior felony arrests, defendants with prior felony arrests were more likely to fail pending trial when compared to those who did not have prior felony arrests. Prior failures to appear. Employment status, defendants who were unemployed at the time of their arrest were 21% more likely to fail pending trial when compared to those who were employed. Defendants who did not own or were not buying their residence were more likely to fail pending trial. Defendants who abused substances were more likely to fail when compared to those who did not use any substances. Primary charge type, defendants charged with a felony were 61% more likely to fail pending trial when compared to those defendants who were charged with a misdemeanor. Primary charge type, when compared to defendants charged with theft or fraud-related offense, defendants charged with firearms, drugs, and immigration law violations were more likely to fail pending trial. The study included recommendations that a standardized, empirically based risk assessment instrument should be developed for use by pretrial services, and there were policy recommendations that were also made. So probably the greatest impact of the study that was done was effectively establishing the risk principle for federal pretrial services. And what the risk principle tells us is that first, risk assessment tools are necessary to distinguish between low, moderate, and high-risk defendants. Second, that lower risk defendants released to the Alternatives to Detention program are more likely to experience pretrial failure when compared to defendants released without the program. Now, when we're talking about alternatives to detention, we're talking about third-party custodian, substance abuse treatment, substance abuse testing, location monitoring, and housing and shelter. And just to kind of expand on that theory of lower risk defendants being more likely to fail, I have an example where I was actually able to see in front of my eyes. I was a cover officer. We went to do a home contact. My coworker was the contact officer. So she was actually the individual working with the defendant on this home contact, and I was able to just observe because no one else was in the home. This was a low-risk defendant. She was released on location monitoring. That was based on the charges. And during the home contact, she actually started apologizing to my coworker, and she was like, "I'm so sorry about last night." She said she had gone to the movies with her children, and she was at the movies, looked down at her watch, and realized that the time was nearing and she was going to be late getting home. So she grabbed her children and she rushed home, and of course it's the next day, and she's apologizing because that was a violation. And I saw at that moment how that's a violation of a condition, and people could face revocation for that violation. But when I listened to her, I realized she really wasn't posing a risk of flight. She had every intention to come to court. She ultimately did attend all of her court appearances. She was sentenced to probation, completed probation. I think she did 2 years on probation and completed successfully. So she wasn't at that moment posing a risk of flight, and she wasn't posing a risk of danger by being at the movies with her 2 small children. So I was able to see that and understand what this risk principle actually refers to. The risk principle also tells us that moderate and higher risk defendants released to alternatives to detention may be less likely to experience pretrial failure when compared to defendants released without the program. And when we're talking about low-risk defendants, we're talking about Petra categories 1 and 2, and then moderate risk being category 3 and high risk being 4s and 5s.
We also we're replicating that study right now, and we use data from 2012 to 2015. I wanted to see, I wasn't doing this in 2007. I didn't have a part in this, but if I'm going to go out and talk about it, I at least want to be able to say it's a working man. Is that the same? What we found was that in terms of lower risk defendants, they were more likely to be successful if they weren't released on the alternatives to detention. Now we know that's not possible in every case, but we have places across the country, and I don't know if that's the case here. We have places across the country that have standard conditions and they place everybody on location monitoring. There are places across the country that you sign your revocation order the same day you sign your release order, so there's no need for a hearing if you violate. We have places that actually order up to 20 conditions on pretrial release. The average number of pretrial conditions nationally is about 12 to 13 for a defendant regardless. That's kind of, it's sort of high, but it's probably because we have some districts, and you'll see from the data when you talk about some of these low release districts that they incorporate a lot of conditions of you are released. One thing we found so far is that the alternative detention that had the biggest impact so far has been third-party custodian. Y'all use that here at all? We used it a lot where I was from. The judge called it mother's rule. He said he believed that there was a bond. This was before Pretrial. He said that there was a bond established between a mother and child that very few people would violate. So if the mother was willing to come to court, and we would do our background on the mother, and that she would be willing to stand up before the judge and accept the responsibility of the defendant, then the judge would be inclined to release them. At the time, we were going through what we call Project Exile, and we would call it, well, we did, in fact, had the most drug cases coming through Richmond and anywhere in the country. Crack cocaine was huge, Project Exile. At the time, that's what the judge would release you on, and we probably had a 75–80% release rate. And our success rate was probably about 95–96%. So when I saw this come out, and it said third-party custodian, I felt good because this was before Pretrial. I was like, oh, at least we were doing it right then. You know, but we have not found so far that any of these cause a negative impact on high-risk defendants. And those are your picture 3s, 4s, and 5s. Those are your pictures, yes, sir.
So I want to make sure I understand. You're saying, though, that if you were to release people to the third-party custodian, they're more likely to offend.
No, I'm saying that they would be more like, that condition right there showed the best level of success of any of the other conditions.
Second bullet, I'm confused.
Lower risk, so basically what it's saying, I'm talking more for these moderate children. I'm sorry, I'm talking for 3s, 4s, and 5s. We even did it sometimes on 1s and 2s. He felt comfortable doing it on 1s and 2s, but generally speaking, what we're seeing is that on low risk, pretty much they're going to apply. I mean, you don't need picture to tell you that what a picture 1 looks like. You kind of know it. Sure, everybody here in this room has seen it. They say, I already knew that. You know, he's probably not going to have any criminal record, have a stable background. But we also see people that on picture 1s across the country. I don't know if that's for certain here. That's hopefully something I can bring out. That if they're released, they're automatically placed in alternatives to detention.
So I was a magistrate judge before Chris. I have no idea what it looks like in practice. The reports going through. But my thought was when I was releasing people on, and they appeared to be low risk, if they were charged, they'd have substance abuse investigative treatment. I just thought that was my duty. Would you tell them for low risk defendant to do it?
You know, we had this conversation at the FJC at Dale not long ago. Judge Carr out of Northern District, Ohio, was there. And I know Judge Carr. And I said, yeah, that's exactly what I'm saying. I'm not telling you not to, but I'm saying when you over-condition, what we're seeing is it has a negative impact across all risk levels. Doesn't matter. In fact, it's one of the things you said, if you want somebody to be revoked, just over-condition. And I'm not saying that's the case here. I don't know precisely, but that's what we're seeing. In a lot of cases, as I said before, you have districts that release people, and the average number of conditions in that district could be 20. That's the extreme, but on average, it's about 12 to 13 conditions, even if you're low risk.
In fact, the study showed that placing location monitoring on a Category 1 defendant increased their likelihood for failure by 112%, is how that came out. So based on the study, the Administrative Office developed the PITRA. The PITRA is an objective, quantifiable instrument that provides a consistent and valid method to predict risk of failure to appear, new criminal arrests, and technical violations. The construction of the tool involved a series of multivariate models. They tested alternate criminal history items, and age and educational attainment were added. And ultimately, 11 factors were selected based on statistical testing. You're familiar with those because you have the PETRA in your bond report, but those are the 11 factors that were selected. Risk categories were developed, and there were 5 risk categories established. And the risk score 0 to 4 correlates with a 1, 5 to 6 with a 2, 7 to 8 with a 3, 9 to 10 with a 4, and 11 plus correlates with a category 5. Each district was validated and revalidated, and it was shown that this tool works in every district. So it's important to remember that the PETRA was designed to be used in connection with a thorough investigation and professional judgment. One of the reservations, like I said at the beginning with my district, when we came in and we understood the PETRA, one of the biggest reservations officers had in our district was that the PETRA was going to dictate our recommendation, that we would know something or have insight on a case, and this PETRA was going to tell us that we had to make a recommendation a certain way. But that was never the way this tool was designed. This tool was designed to be used combined with a thorough and complete investigation and with our professional judgment.
And that's sort of new. I say this to districts. We did a great job of implementing this tool. I'm not sure we did the best job of educating on the tool. And this may be one of the biggest things, and I'm talking from the administrative officer from PPSO, to get that out there. And so I've heard it all, pretrial guidelines, data numbers, things like that. That's all you're trying to do is make data the main thing. I would never do that. I don't preach this, I don't talk it. She doesn't teach it when she teaches officers now. The tool is not the number one thing. The way we look at it is you start with your investigation. After your investigation, as part of it, you complete your PITRA. And then, as you're assessing that defendant, use your professional judgment to come up with a recommendation. Now, I wanted you to make sure, especially some of these PITRA 3s, they're very difficult to be able to understand a PITRA 3. It can go either way. And the hope is that, like I said, many people know what a PITRA 1 and 2 looks like. Just like we know what a PITRA 5 looks like. Y'all see them a lot here in this district. Trust me, y'all have a lot of high-risk cases. But that PITRA 3, that's the largest category of defendants in the country. And they're the cases that they have about 80%, 8% at the time success rate at the time of this study. It's even higher now. You're going to see it's probably in the 90s. And they're probably released at a rate of 40%. And that's where I said, where the PITRA can help the officer. It can help them to understand, well, hey, this person is likely to be successful if they're placed on these conditions. It does not make the final decision for them.
So when we combine the PETRA with our investigation and our professional judgment, then we come out with a reasonable recommendation for the court. So what the PETRA is and what the PETRA is not. Well, the PETRA is an evidence-based tool. It does not weigh the evidence. We recognize that only the judicial officer weighs the evidence. We as officers just use the PETRA as a tool in making our recommendations to the court. It is one factor of many. It should be used with a thorough investigation, professional judgment. It's not a standalone tool, and it's an objective tool. It's based on facts. It's not subjective. We complete the PETRA prior to making a recommendation to the court. So like Bill already said, as we're working on our investigation, we complete the Petra, and then we make a recommendation, factoring that into our recommendation. And this chart just outlines the steps that a pretrial officer goes through when completing a pretrial investigation. And you can see that the Petra actually falls into the second column, pointer toward the bottom. So we're gathering information, we're interviewing our defendant, thank you. We're gathering information, we're reviewing our charging document, and then we get into the process of actually verifying information and completing the Petra, and then we do an assessment for danger, non-appearance, and provide a recommendation.
And you can see, as we move forward, there's so many other things that happen outside of this. The picture is here. Then we talk about what we assess and provide a recommendation. So we still have to assess. It's not, here's the picture, it determines your recommendation. We're still assessing. We're still making our own and using our professional judgment to come up with a recommendation.
So there are several factors that are not addressed by the Petra. It doesn't, under substance abuse, it doesn't address the age of onset, the types of substances, the length of use, or prior treatment. It doesn't look at the history of charges involving violence and domestic violence. It doesn't look at abuse of a child or use of a computer to facilitate an offense, or weapon use or illegal possession of a weapon, or any criminal association or gang involvement. And the Petra is actually not optimized to predict violence because violence is a rare occasion, but there is a study for violence going on, and so hopefully in the future we'll have a little more guidance in that area. It also does not accurately assess risk for defendants charged with sex offenses. However, it can still help us in developing an overall supervision plan for the case.
Yes, sir. I want to address that because that's a big thing. It's the reason why I'm doing we're revalidating. We want to be able to assess violence. I want to. I want to explain to you why it's still a very rare event. It's less than, I think it's less than 1% or something like that. There was a reason why sex offenses weren't involved. At the time, from 2001 to 2007, they weren't being charged like they are now. There were only 1,700 cases out of that subset. That's not enough for us to be able to come and say that that data is good with the results and outcomes we would get. And that's the reason why he did not. At the administrative office now, Michelle Spidell, who's the expert on sex offenses, she is working to create a tool that would develop risk for sex offenders. I'm working on optimizing it to balance, even to say if we break it down where we can predict violence while on release, who would be more likely to have a violent offense. That's what Dr. Lowenkamp is working on now. So we recognize some shortcomings. Since we're talking about that, I just wanted to know, I got a lot of people in this room. What do you think of some of the shortcomings of the picture? It ain't perfect, so anybody? Interesting.
One of the things we score on Petra, Petra is their residence, if they own the property or if they're renting. We've had offenders that have rented the same place for years and years and years and years and really have no intention of going, where we have those may have bought a house and they're gone. Right? So I don't know that ownership is as much of a factor as is stability, time in a specific residence or community.
And that's an excellent point, and that's something that was brought up previously. And I'll tell you now, as it would stand now, this is what I would say to you. This is when I say your professional judgment there would override that. If a guy's there for that time, that's when you use your professional judgment. I don't think the picture, if I score 1 point there and they're low risk, I don't think that's going to make a difference, but we are looking at all factors now. We're not just going and saying we're going to just stick to this. I asked Dr. Lowenkamp to go back and look at all the predictors that we had, and see, and retest them. Same way I retested the conditions.
So I think one of the the flaws of the picture is if you look at the factors closely, there does seem to be a much higher likelihood that a person in a minority community is going to score more negatively. And for the primary example of that for me is prior arrests. You have minority communities that are being monitored more, stopped more, frisked more, arrested more, prosecuted more, unable to pay their fines more, which racks up their pending cases and their felony convictions. They're more likely to be charged with felonies rather than misdemeanors. And they have more issues in those communities with employment and substance abuse. And I just feel like I've read some studies that basically say that as helpful as the picture is, it can also unfairly burden minority communities just by the nature of what's being counted. And poverty too, not just race, but poverty.
Right. We did look at the scoring, and what we found was that these factors, these other factors, that generally speaking, when we looked at blacks and whites, very rarely will the AO go and look at race. We just don't, we stay away from it a little bit. But we found that blacks and whites were similar in terms of the dynamic factors. Okay, that's this other section. That's residence, employment, education, substance abuse, things like that. Where they had the most differential in points was, you're right, in the criminal history. And it was almost 1.5 points. I think it was 1.37. Was the number we came with. I know we can't control criminal history. What we tried to do was to take out that bias of how I may look at certain types of criminal history versus what you would look at certain types of criminal history. That's what the picture was trying to do. It was trying to say we may differ on how we view a drug crime versus a firearm. I may have more firearm issues with firearms because something could have happened. I don't know, in my family, I just ended, that implied bias, so to speak. But that's what it was attempting to do, was to minimize that. It's not perfect because criminal history itself, we can say it's biased. You hear that all the time. Well, I'll sit here and say there's no bias in the picture. I cannot. I know Dr. Lowenkamp did a study on post-conviction, and he just released it. I can get it to you. You can take a look, and that's involving the Pickwick, which is far more in depth than us, than what the picture is. And he put a paper out on it. And I said, well, can you look at the picture as well while we're doing this revalidation? And we hope to be able to do that as well. That's a good question. Anybody else? I'm not here to say the picture is perfect. We can't. But we do think it adds some value. I think it adds significant value. You'll start to see, especially when you start looking at your defendants, and we can break them down by risk categories when we get into the data.
So the current national average on Petra timeliness, and when we calculate Petra timeliness, and again we'll go into this more in the statistics portion, is that we're completing it prior to making a recommendation or prior to the judge making a decision. So the current average is 70%. And what has been shown is that when the Petra is effectively used, it actually does its job, and the district does yield lower rates of unnecessary detention. So when we looked between 2010 and 2013, and those districts that used the Petra the most, with the highest rate, they had release recommendations that actually increased. Those districts that were less quick to get on board with the Petra actually had lower release rates.
Sarah, is that just a function of the fact that you have more information, you have the information on the factors of the different? Is it just that, really? It's information on the fact that it's a score?
You're saying that they would have a higher release rate?
But if the more information you have, the more secure I think you feel as a judge about the release. So PITRA requires you to get all these measures in those whatever 10 or 12 categories. So it seems that that's really the mark of diligence, isn't it?
Right. What it's looking at is release recommendations with full reports. So you have the information, because the picture, that it's the same information we see in the bail report anyway, generally speaking. You know, a lot of that is the same. So we're saying, if you didn't use the picture, you presented that full report versus the district who completed the picture with a full report. This is what we were seeing. It wasn't the no reports that we get because there was no interview.
Okay, both of those are full report.
Yes, we excluded those no interview reports because that happens a lot. You don't want to hold officers responsible for a low picture implementation where they never had a chance to interview. So I, generally speaking, when I look at that data, I kick those out.
So in summary, research suggests that pretrial defendants who fall into a category 1 have a 97% likelihood of success when released with minimal conditions. Those defendants that fall into a category 2, research suggests they have a 91% likelihood of success, again, if released with minimal conditions. Category 3 defendants have an 82% likelihood of success when released utilizing alternatives to detention. Category 4 have a 72% likelihood of success when released utilizing alternatives to detention, and Category 5 have a 65% likelihood of success when released utilizing alternatives to detention. Yes?
What are considered minimal conditions?
Again, not over-conditioning. Like the research showed, when you impose alternatives to detention on low-risk defendants, it actually sets them up for failure. So now there is an exception to that. Mental health is an exception. Mental health was found to be appropriate at any risk level when it was needed. So a Category 1 defendant may be released with no conditions. They may not have any identified risks that we need to impose a condition, is what that's telling us.
And what you mean by minimal? If you have a risk factor, if they don't have a residence, it makes sense to have a residence condition. If they, but don't just say, they say, I have no passport, right? And a lot of times we see, I'm not saying to do it, but a lot of times you see no travel outside the state, and the guy's never left the state anyway. We start adding on conditions, or there's no history of substance abuse, and just put substance abuse testing. You see that one a lot. There's no history of firearms, none in the residence, but we say, that's no firearms. This guy may be a picture one with no criminal history, charged with a white collar case. You just never know. But you see that, and that's where we see standard conditions happen a lot. Like for mine, one was no travel outside the Eastern District of Virginia. I said, well, guy never left Richmond his whole life. He's not going anywhere, but it was a standard condition we put on. We're just trying to minimize the over-conditioning. Conditions should address specific risk. That's what we're saying.
Right, Richard, the fact is,
It's least restrictive, so to address whatever, yeah.
The statute says the least restrictive conditions to address the risk.
So in summary, failure on pretrial release can be predicted with a certain level of accuracy, and a risk score can be used to guide placement of defendants and to guide appropriate conditions for cases. Does anyone have any questions? Yes.
What about the burden that utilizing the picture within a short period of time, the burden it places on pretrial and the burden it places on defense counsel to get all of this information in a presentable fashion?
So the Pretrial is actually designed, it's a very short tool. It doesn't take much time. I think the other officers would probably agree with me that it doesn't take much time. It was designed to be fast and quick, recognizing that pretrial officers are usually working in a really quick time pace under a lot of pressure. So it can be scored with up to 4 missing items. But we have to have the criminal history score. And generally, pretrial officers, we would have the criminal record. We usually try to get those done as soon as we can.
And I think the biggest issue officers would say they have is time. to complete the report. No matter where I go, from the time of arrest to the time of the hearing. You know, it's difficult to give you a tight report at the hearing. It's difficult to get that done in an hour. It's difficult to get it done in 2 hours. The picture pretty much takes, you plug in the numbers, it takes about 5 minutes, it's done on the computer. They can do it by hand if they wanted to, but at the same time they're entering in their report, they can enter in that picture and it kicks out the numbers for them. They don't have to calculate it. What officers find is the biggest thing is access to defendants in a timely manner, and then the time between the time of arrest when they get the access to the hearing so that they can get a detailed report. Yes?
So in these low-risk people, the 24 hours seems to be a significant factor. We should be having a hearing at the initial appearance, and so there needs to be time, you're saying, to have that done. So if there's not time to get it all done before the hearing in the morning, maybe we should have hearings in the afternoon?
Yes, I'm going to stand up and say, look, this is what I found, that if you could get that done that day, get it done. I come from a district that we had the 3-day rule. The prosecutor said it was done. 3 days, automatic, especially in a presumption case. It doesn't necessarily have to be that way, especially in non-presumption cases. That if you ask pretrial and you say, hey, I don't have a report, what time, how long will it take you to get one? They can get you one in a couple of hours. So if it's not in the morning, yes. Because if somebody's a low risk with no criminal history, and you know we're ultimately going to release them, why would we detain them? If it only takes us to take more hours. Here's the problem. I don't want to burden the judge's time. One of the things I've seen in this work is if it's not ready by the 11th, we're going to do it at the 3 o'clock hearing. You know, that happens sometimes. You understand? So I don't know if y'all have set hearings here, but okay, that's something that I've seen work across districts. You know, and that generally is for your lower risk. I'm not saying for if the guys are petrified with charged with a presumption case, we know that's going to be very difficult. And we're going to come in and say, you know what, we better do this. And that's not practical. But for a low risk person, yes, because it may be something, it may be an issue down the road where it can help them, and or at least it could save a job if they're released, which makes them more likely to succeed, which makes these officers' jobs a lot easier in dealing with them in the community. Great question. Anything else? Well, we're going to take a break, and I see we don't have any more questions. I hope everybody comes back. I hope we ignored you to death. The next thing we're going to get into is the data. So at the very least, you may want to see what your data looks like for cases where officers are doing interviews and investigations, what it kind of looks like, what the difference between the release recommendations are between ours and the U.S. attorneys, what our crimes look like that we're seeing here. And you're going to see what I saw was that you're dealing with a high-risk population. Bet you're probably saying that right. I know that, Bill. So let's take a while for us to switch it over. I want to try to see if we can still get out of here. Let's take about a 5 to 10 minute break and then come back in and get started. Let's say take 5. So if you have questions at the end of this, you could ask me. I know we went through a lot fairly quickly, and I can tell you we're not going to go through 5 o'clock. We're going to be out earlier than 5 o'clock. Some of you are probably happy about that. So you've been in a lot of trainings this week. So we're going to be out faster than that. This next section, the statistics, you know, depending on some of the conversations, some of the things that you asked and pointed out, probably will take about an hour 15 at max. So we will get you out of here a little early. But if there are anything, questions that you have about the previous presentation on the picture, feel free to come by. I have my cards with me and I can give you that as well. So I'm going to turn it over to Sarah now to start with the statistics.
Thank you. So in this portion of the drop data, we're going to examine the release trends nationally and in the District of Utah. We're going to talk about how the Petra informs pretrial release decisions and recommendations in Utah. And we're going to explore the divergence in pretrial release across federal districts. So when we look at statistics nationally, we often look at the national average. I think that's usually what we make a comparison of. And it sounds like several of you attended NAPSA last year. Bill and I did a presentation on the top 10 districts in the nation. What we thought was significant is we look at the national average, but then we often will say that the national average isn't maybe the best, or we wouldn't have this program if we didn't need to reduce unnecessary detention nationally. So just to give you an idea and a starting place, I included some of our slides from the top 10 presentation that we did last year, just showing kind of what the top 10 in the nation actually look like. So to begin, these are the top 10 districts with the highest release rates in the nation. And so what you can see from these top 10 districts is that their average release rate is 70%. The national average is closer to 50%, so that's important to know that the top 10 is 70%. And these are the top 10 districts where their officers recommend release at the highest rate. And again, what you can see from these top 10 districts is that the officers are recommending release about 71% of the time. That's pretty consistent with nationally that officers recommend release slightly higher. And these are your top 10 districts in the nation for Petra timeliness. Again, we measure Petra timeliness based on getting that Petra completed prior to the judicial decision. Yes?
The slide shows prior to the same date, judicial decision, it would be easy to have sickness for
So this includes all of that. If the judicial decision is at the initial appearance, then that's when the Petra should be done by that day. And then if it's done in a detention hearing 3 days, then it's that day. So this is an average for both of those scenarios.
Okay, but we don't know what Louisiana's really is doing to 100%.
Oh.
I get what you're saying, yes.
Right.
We do have it where it's broken down, and it's called DSS 1277. Jeff, can you get that for you?
I knew that.
And so, and he can get that for you so you can see the Petra completion rate at the initial and the Petra completion rate at the detention. But what we generally do is say we incorporate both when we say by the judicial decision. But we have those numbers.
So the average of the top 10 districts, Petra timeliness is 88%. And it's really hard to have a top 10, I explained this last year, for outcomes, but there are 17 districts in the nation that have their failure to appear, new criminal arrests, and their technical violations leading to revocation rates are below the national average. So these 17 districts, they're below the national average in all cases. So here is a comparison of the top 10 districts in the nation as far as their highest release rates compared to the bottom 10 districts in the nation with the lowest release rates. And what we see here is that there's a very wide divergence. You have the top 10, the highest release rate in the nation at 74%, and the lowest release rate in the nation at 24%.
And, you know, this slide is very important to me because you asked me why do I do drop. When I looked at the numbers, it was this. So the divergence between release rates. This slide showed me why I do drop. So if you take a look at, for those, it's up on that board as well. What's important about this slide? You have two districts within the same state that are in the top 10 in the country. But you have one district from that exact same state that's in the bottom 10. How is that possible? Is it that they got different charges? No, they're not that different. Exact same state. Did anybody see what the state is? Oklahoma East. Georgia has, yeah, Georgia, but we don't have Georgia Northern. So Georgia Northern, they're, yeah, they are, actually. I just realized that. That's new. Yeah. clearly it. Yes.
So this shows the percent released. Is there another slide that's going to show us the percent violated on pretrial release?
Boy, you're good. You're good. You're good. Because that's not, I said it earlier, right? It's not just are you released, right? It's your outcomes. Bottom line. If they're getting rearrested at a high rate or they're failing to appear at a high rate, then look, we've not fulfilled our statutory obligation. That's something I really want the officers to focus on in terms of education.
And these statistics purely take release and detention. They don't take charges or any of the criminal history or any of that.
No, right now, this here is just your age table, which is just pulling, release, and detention. Generally speaking, in terms of charges, though, this district is different, somewhat different in terms of types of charges. I will say that now. More so than a lot of the other districts that I've visited, you deal with, and you'll see that in the slides.
But whenever we talk about release rates, we do always get the question of, well, what about their outcomes? What about violation rates? And so this slide actually shows you the comparison of the outcomes for the top 10 districts and then those bottom 10 districts with the lowest release rates. And what you can see on this slide is there isn't much difference. We often think if we have the highest release rates, they probably are going to have the highest percent violate. That's why we would be reserved or afraid to recommend release. But you can see here that there is no difference. This looks at new arrests and failure to appear. Where there is a difference is in technical violations, and it's generally the bottom 10 districts will have a slightly higher rate of technical violations, and that can often be attributed to just their approach to supervision. If they're less likely to release people, they're probably less likely to use graduated sanctions, more likely to revoke people quickly for violations. I think this is interesting. They presented at NAPSA one year, I don't know if you all remember, when they asked the crowd, what's the #1 indicator of whether you'll be released or detained? Anybody have a thought?
Tattoos?
Tattoos. Most people say criminal history, but what they found was it was the culture. If you're arrested in a district where it's a culture of release, you're probably going to get released. If you're arrested in a district with a culture of detention, you're probably going to get detention. There was no other identifiable factor that said whether you'd be released or detained. So here are major trends in pretrial release nationally and in the District of Utah. So where we start is in pretrial activations. And what we can see is that pretrial activations increased from 2007 to 2011, and then they declined. That's excluding immigration, and these are national rates. See in this slide.
What's an activation?
When a case is activated, when they're brought in and we activate the case.
This data is, a lot of this data is based off of pretrial. And I can't pull the U.S. Attorney's data of all the cases he prosecuted, I can't. I don't have access to that. What I have access to is the cases that come before the probation office. So if a case is activated in pretrial services, we become aware of it, they do anything on it, it gets a number called a PAX number. From that PAX number, I take the court data. So the information you're seeing in this is based off of the information that's come from the district through the probation office.
Now, in the District of Utah, pretrial activations actually declined from 2007 to 2011, but they have been increasing since 2012. And well, it sounds like you may have a large percentage of illegal aliens, but you don't have, it doesn't seem like there's a lot of immigration cases that make a significant difference when you look at this. In the District of Utah, the trends in the offenses charged has been relatively stable. You can see that the largest percentage are drugs, followed by firearms currently, and then property, sex offense, and violence. Those are the top 5 charges in the District of Utah.
And generally, that's where I said you all are different. Where look at your drugs and you know, so the drugs and firearm cases shooting up. It may say stable, but the reality is, look at 2015 to now, you really starting to climb, and that's your trend. Even if going back to 14, it seems like you dipped until 14 with drugs and firearms, but now they're both starting to climb. I heard that sex offense was something that you deal with a lot. And what you may be seeing, and people probably want to argue, that you may have shown this huge, big increase from 12 to probably 15, but 3% may not be a lot in terms of your overall numbers. So while it may look like that, it may not be statistically that relevant. What's probably more relevant is when you look at other cases, you see you have a lot of drug and gun cases.
So here you see the offense type distribution compared to the 10th Circuit and the nation. And what you can see is that the District of Utah, like Bill said, has a greater number of drugs, firearms, and sex offenses when compared to the national average and to the 10th Circuit.
Where would the 10th Circuit, where most of their cases be? Because those 10th Circuit and national numbers don't come anywhere close to adding up to 100. Where are they charging and where not?
Immigration.
So you could have, some cases maybe immigration. So you look at these, and we're only looking at the top 5 for here. There are other cases that can fall into that category when they pull the data, but we're mostly focusing on your cases here. And other people may have more different cases that they focus on. What we're trying to look at is, what are your big cases? And what are their big cases? So they may have a lot more cases in anything. We have a category of other, but what we're saying is they don't deal with a lot of firearms, a lot of drug cases, just not, you're far outnumbered them. Does that make sense? So we're really focusing on you here. I'm not looking at everything in the national.
In the District of Utah, release rates for property and sex offenses are relatively stable, but you've had a large decline in release rates for drugs and firearms offenses. This is comparing 2013 through 2016. And so you can see in firearms, you went from 38% down to 18%, drugs. So for the most common offenses, which are drugs and firearms in the District of Utah, you released a lower percentage of defendants compared to the nation and compared to the 10th Circuit as well. And this is looking at 2015 to 2016. It's 1 year of data. Nationally, the percentage released declined from 47 to 41%, while release rates in Utah were higher than the national average from 2011 to 2014. We saw your release rates decrease starting in 2014. So you ranged from a high of a 60% release rate down to 40% in 2016.
And I tried to analyze that, and I don't know, maybe you all can help me, but what I thought it was, had a lot to do with, like we saw earlier, the increase in drug and firearm cases right about that time. And my understanding is that in this office, the federal U.S. attorney does a good job of working with the states in terms of deciding on what cases they want to bring forward federally. And therefore, they're bringing in more high-risk people. And you're going to see that as we start looking at the categories of these folks. And I don't know for certain, somebody may have a different opinion, but when you see a rapid decline like that, generally you're trying to find what's the cause of it, or is there a correlation? And the correlation I'm seeing is that you're right about that same time was when your drug or firearm cases went up. And then you saw it, but the people that you're going to see that are coming in, and it makes it a very difficult thing for you to identify who to and who not to release. But I think there are some ways we can look at it, but I think it makes it very difficult.
So here you can see again those release rates over the 4 fiscal years and compared to the nation and the 10th Circuit. Just see the numbers again. The percent of defendants released in Utah ranged from 61% to 43%. This is excluding illegal alien cases. The other slide was excluding immigration cases. So excluding illegal aliens, officer release recommendations were similar at the national level. In Utah, there were fewer defendants recommended for release than the actual release rates. So again, you saw that saying the decline in actual release, and that was consistent with officer recommendations as well.
So, I just asked here, this table on the right is showing that Utah, the judges release more than the officers recommend release.
It
Is
is.
that correct?
That's correct.
In all 3 years.
That's correct. And generally speaking, officers recommend release at a higher rate than judicial officers release. And that's because we don't consider things like the weight of the evidence, presumption. You know, so, but in here, it is different. Here's your slide, Judge.
I have a question.
Oh, I'm
Yes, sir.
You indicated you don't consider weight of the evidence and so forth, which I'm aware of. So why should a judge rely on a recommendation that doesn't take into account the most essential factors the judge needs to look at, meaning the nature and circumstances of the defense and the weight of the evidence? Because if you're making a recommendation and you're not considering that, it seems to me that recommendation has no value.
I can understand the point, especially when you're considering those factors, sir. The role of the officer and the expertise of the officer is the background of the defendant. And that's what we look at. We can't tell you that because of presumption, I can't tell you we're doing a study on the presumption of detention now. I don't want to get into that, but I can tell you
I
that.
don't even care about presumption, I'm just talking about nature and circumstances and weight of the evidence.
Yeah, the OGC, Office of General Counsel at the Administrative Office, told, it's been very clear that we cannot look at it. And so,
You're misunderstanding. I'm not suggesting that you should, I understand you can't.
oh, okay.
My question is, why should a judge give much weight to your recommendation when you don't consider the very factors the statute requires us to consider?
But I think the statute,
3142, the statute requires us to consider first the nature and circumstances of the offense, and 2, the weight of the evidence.
and characteristics of the defendant as well. I think
Yeah.
that's where we
Those 2
fall.
factors are 1 and 2 on statute. And yet you give me a recommendation that you, by policy or procedure or rule or opinion, cannot factor in. So by definition, your recommendation is of very little value to me when you don't look at the very things that I'm required to look at by statute.
I hear your opinion, sir. I can say that here's mine. Our role and what we look at, we provide you a recommendation based on that. That is part of the things that a judge should consider. And the value of it is what a judge may consider individual. I can't tell you you're right or wrong. I can tell you that some judges say, I value that pretrial recommendation a lot. I can tell you some say exactly what you say to me from my travels. I could care less about the officer recommendation. But what I can tell you is our role is to look at the categories, background of the defendant, and make a recommendation based on the type of charge and all their personal characteristics. And then the judge can take into account all the things that they hear through argument and testimony that we cannot. And that's the best I can tell you, because I do think if you took out the fact whether an officer gave you a report, you had no background on it, it would be a problem.
The best part of the report, from my perspective, is all of the information that the officer gathers. The background history, the nature of this person's contacts in the community, job, et cetera, et cetera, et cetera, et cetera. That's extremely valuable. The recommendation is of no moment to me because it's flawed. It doesn't contain the very basics that I have to consider. So that's my point, is I love the report. I love these guys who worked very hard to give me this report. But I gotta tell you, it's the information in the report that counts. It's not their recommendation. Because by policy, they can't give me the basics of what I really want to know.
I understand your point. And we've looked at it. We can't, what I can tell you is based on the information they provide you, what they're able to look at, they provide you the best available recommendations. Some judges take that into account and say, this is what I need, because the background of the defendant means a lot to me, especially low-risk folks. And I value the officer's recommendation because they're the experts. They do this day in and day out. They supervise these people day in and day out. They know what works when they make a recommendation. But I can't tell you, Judge, that if you say to me, I don't value your recommendation, I can't argue with you, tell you not to, or to do that. This is your own individual assessment of the report.
And let me just emphasize, I really want to emphasize this. I'm not saying that I don't value the work of the officer.
Oh, I know you're not saying that. Oh, I don't think
Because
that.
I love my pretrial services.
I know you're not doing that,
What
Judge.
I am saying is their recommendation is flawed in my opinion because they're not allowed to consider the things I want to do.
And your opinion is not different. Than some judges I've talked to. It's not. And then there's some that may not say that.
Have you done a study or research as to whether pretrial service recommendation changes after we learn, say in a detention hearing, about the nature and circumstances and weight? My guess is that those opinions might change, and after all, you've emphasized how they're supposed to use their professional judgment. How can they do that when they don't have that full story?
No, those things, those facts, generally speaking, you get the report before that detention hearing, or that hearing where you're hearing evidence anyway. So generally speaking, that recommendation doesn't change. I don't know if that
No,
happens.
I know that. I'm talking anecdotally. We'll talk to pretrial service officers and they'll say, had I known A, B, C, and D, my recommendation would have been different.
And it takes courage to do our job, because I get it, but I get it. But I tell officers all the time, it takes courage to know your job and to stand up and do it. But can you say, would their recommendation change? That's when we get into our own personal biases based off of what we hear. I will say this, I also said this before. Once you hear it, it's hard to unhear it, right? So if I hear this guy's presumption with this and this and that, I've been through it before. Well, I question my own personally. Professionally, it's a different story.
You may be aware that we do ask them to put the presumption in our pretrial service reports, number one. But number two, you mentioned the disparity. Some districts value the recommendation highly, other districts disregard it entirely. What weight do you propose be attached to the recommendation of the pretrial service officer in light of this massive disparity and the absence of those two critical factors?
It would be difficult for me, that's more of an OGC, because I can't say even now that I can look at the legalities of what you look at. I don't, it's not by statute, I'm not allowed to look at it. But from what the officers put out, what I would say you look at, that recommendation is based on, they look at the nature of the charge, they look at the background and characteristics, they investigate the home prior to the person being released. They look at all these things that you're also going to consider if you come to a place where you can say release. And I think that's what they're valuable at. Because the expertise is they do this day in and day out. They know these people.
I totally agree, but my fear is that their recommendation is, this is our recommendation, but we don't know A and B. And A and B could be the most critical factors. And my suspicion is if we ask pretrial service officers, after a detention hearing, would you have made a different recommendation knowing what you know now? The answer is probably going to be yes, in many cases.
And it shouldn't be.
Well, now they've learned information that has caused the judge to detain that person.
That we can't consider.
Or release that person.
Yes.
Yeah, both ways.
Yeah, if it's something, the weight of the evidence, if you go into a preliminary hearing, preliminary detention hearing, and you find out that the weight of the evidence is weak, and then the judge, well, he's a picture 4, and the officer has made a recommendation for detention, because of that, they shouldn't just turn around and change their recommendation for release. If they didn't believe that the factors they looked at prior to change, they can't consider it. Just the same way if we know somebody is very strong, that is not our role, and we don't have the training or the education necessary. Not all, but some of us are lawyers, but we're not lawyers. And even by way the statute says, it says the judicial officer shall. We don't have that expertise. So I do understand what you're saying. I do. I mean, I struggled with it as an officer sometimes myself. My personal opinion versus my own professional opinion. but it takes courage for me to stand up to do my job. And that's what I say to the officers. It may not be sometimes everything believed personally. You may have your own bias, implied bias on something, but you have to step aside and do your job.
So here we're looking at outcomes. Nationally, the percent of defendants rearrested or who failed to appear has remained stable. Those are down here. There's been an increase in technical violations, but failure to appear and the arrest have remained stable. In the 10th Circuit, the percent of defendants who have been rearrested or failed to appear has been stable, and there was a slight increase in technical violations since 2013. And in the District of Utah, rearrests and failures to appear have actually declined from 2011 through 2016. And there was an increase in technical violations leading to revocation from 2015 to 2016.
Can we just stop there for a minute? Are you
Yes.
telling me that nobody failed to appear in 2 years?
That's what the data shows, Judge, and that could be something that we look at as a data issue.
Okay, but then you're also saying that from about 5% rearrest while on pretrial release, right? That's what this number is. But almost 5% back in 2011, 2012, we dropped to 28%.
That's right.
And could you tell us why?
Why? Because we're not releasing. Yeah, it's who we release, right? We're releasing white-collar criminals who have got one thing in their history and they're scared to death, so they're not going to violate or they're not going to be to us again. We're detaining everybody. And that's, so the ones we are releasing are less likely. So they're the very bottom likely to be.
And what you slipped in there is your observation that we detain everybody except the white
Almost. I did not mean to make that inference.
You did.
Yeah, I didn't intend to address that. We release, those who release are going to be the ones and twos, because, because they don't have much criminal history, and they have a whole lot more stability, like they own their residence, their citizens, and those types of things, opposed to the others who are detaining, so their picture score would be considerably higher. Because what's happening, I think, here is that because the U.S. Attorney's Office is working with the state deals with these offenders for a long time, to the point where they work with the federal officer and the federal judiciary to bring those more serious criminals to us. And so that may be why we have a lower release rate, because the criminal histories of the people we're bringing in, we have a guy that we're doing a criminal history on that has 50 arrests. Okay. And we're not talking about shoplifting, right? And so that is going to affect our rate.
Thank you.
I agree with you that people you release probably has an effect on those rates. Absolutely.
I've worked.
My only question will go back to, sir, if you talk about over condition, low risk defendants, look at your technical revocations, look what happened. If that makes sense, now look at your technical violation. That's my only point I want to make on that in terms of what I talked about over condition in the first session. That's more the illustration.
Here's my question. So if we got a person comes in as a 2, and we don't impose it, the judge doesn't impose a condition for drug testing, but they're out there using drugs, we're not going to be able to find out whether or not they're a technical violation because they're not testing them for drugs. So the imposition of conditions, I mean, is obviously going to affect the technical violation. I mean, so
But does
we're
it
just not
address,
finding it. We're not.
does it address a risk? So if a person has no history of drug use, there's no drug use in their criminal history, and they're charged with a drug crime, and we place them on drug testing, what risk are we addressing? And that's the bigger point I'm trying to make. I can't tell you what caused your jump here. I'm just saying there's the correlation I talked about. If he's saying that this is who we're releasing, white collars with no criminal history, no this, no that, then why are we having an increase in only technical violations while everything else is decreasing? Yes, sir.
Do you have an overlay of where those numbers are relative to what we see in the picture? I think those numbers are better, if I remember, than what I see the picture.
The picture category?
Yes.
Oh, you mean a comparison to the research?
That's across criminal
No,
history,
I-
but, and category.
No, we don't on this one, but that's a good point, and maybe something you probably want to see. Where is it that we have in those technical violations?
Yeah.
Bill?
Oh, yes, sir.
One other quick comment. And happily, I'm unencumbered with facts and statistics. This is anecdotal, okay?
Yes, sir.
Rarely do I like to be confused with facts, but here's my thought. When they talk about encumbering people in too many conditions, I get that. But it seems to me that these are self-fulfilling prophecies up here. If we don't put any conditions on people, then there's no conditions for them to violate. The more rules you make, the more rules they break. But the fact is, there's a reason we don't want people having firearms who are under a federal indictment, because these good people who I love dearly, and I mean that sincerely, my pretrial service officers have to go out to their homes and places where I wouldn't want to go. And I like the idea that maybe my restriction has kept them from going out and getting a firearm that might be used to hurt one of these people. So I think that's reasonable under any circumstances, whether they possess them or not, because in the past, they haven't been under federal indictment. It's the same thing to your point about them not leaving the district. Why do we put restriction on them not to leave the district? Well, because in the past, they haven't been facing a serious criminal charge. They didn't have a reason to leave the district. Now they have a reason to leave the district. So if we don't put conditions on, of course they're not going to violate, because there are no conditions to violate. I don't believe in over-restricting, but I don't think we ought to put our head in the sand and say, oh, there's no reason to put a condition like don't get a firearm, when I got to send Lauren or Charlie or Scott in there and face these situations where they may... Exactly, of course.
Right.
So, but my point simply is that nobody thinks, I say no one, I certainly don't think we ought to over-restrict or put conditions on, but I think we should put our heads in the sand and say that everything is conditioned on this person's history. We have a new factor, the new factor being the nature and circumstances of the offense and the weight of that evidence. So those restrictions or conditions, we call them, are really important, not only in terms of that defendant, but in trying to protect these people who have to go out there and do it every day.
And that's what we should be doing, is the least restrictive to ensure the appearance and the safety of any other person in the community. And that's all you're saying.
Right.
I agree with you. I'm not telling you not to place conditions, and I said that earlier. I said what we don't want to do is over-condition, and I said this may be, I don't know. You would have to take that look and say, what is it that's causing our numbers and technicals to jump up so significant? 4% is a big jump here in federal rates. And that's all I'm saying, is to take that look at it, but by no means am I telling you release everybody without conditions. I don't release them based on the risk. You have to, as a judicial officer, weigh so many other factors. As you said, there's a new thing on that now. They're charged. I've seen the weight of the evidence. We know what our conviction rate is. I get that, but what we're saying is, do you need to place everyone on the same conditions unilaterally across the board? I don't know. I'm asking you to just look at the least restrictive.
Well, do a lot of districts not have standard conditions of pretrial supervision release?
Yes, a lot of districts do not have. There are fewer districts that have those standards than there are who don't. So more districts are more inclined. That's where you see it, especially in the movement, that they're not going to have a set standard condition of release. Now, I can tell you, where I'm from, I had one judge We swore it down. He was going to sell travel, a firearm, drug test, the whole 9 yards. And I had another judge who wouldn't do that. It just varies.
So I thought the AO form has those in it.
It does. The 199 has all those conditions in it. Doesn't mean that they all have to be ordered. But a lot of people do. You know. Second. Yeah, Part A, the 199. No, you talk about those 4 or 5 standard conditions? Yeah, that we have to, like DNA testing, report any contact that's on there. Yeah, that's not what we're talking about here. We're talking the special conditions. Yes, that B, 199B, I think it is. That's the one you want to look up. We have all the special conditions. The standard conditions, when we look at the study, we remove them because it's standard. I mean, you have to put that in. We're not talking about those. We're talking judges who repeatedly use standard special conditions.
So taking a look at the Petra to understand recommendations and release decisions nationally and in the District of Utah. So starting, these are the percent of defendants interviewed by pretrial services officers. And what you can see is that in the District of Utah, you have much higher rates of interviews than the nation and then the 10th Circuit. So like the judges have already said, your officers are working really hard, interviewing a much higher rate of defendants. This is the Petra completion rates, of course, the timeliness. And in Utah, you have a 77% of the time you're getting that done prior to the judicial decision. So again, you're higher than the national average. Again, showing your officers work really hard to get their interviews done and get their Petras done timely. Now, the District of Utah, we've hit on this a couple times, you actually have significantly more Category 5 defendants than the nation. You can see there.
20%. Almost 20. 18%.
3 times as many.
Yeah.
High risk. You're similar on your Category 3s and 4s, and you have fewer low-risk defendants in this district, actually.
So does this mean all our pretrial officers run for the
Everybody else is used to.
They're loving me right now. They're like, thank you, Chris.
So compared to the nation, the District of Utah has pretrial release rates are comparable or lower across all Petra categories. These are actual release rates. So nationally, it's about 45%, Utah about 30%, 6%. And compared to the nation, officers in the District of Utah recommend release at a lower rate by Petra category. Pretty close on ones.
But is it safe to say that the national average is significantly beneath what certain districts are doing? And that
Great question. I say it all the time. Well, the national average is an average. What makes that great? You know, when you have people, you clearly have people who are high. You know, I think it's a good bar for you to say, look, you know, let's take a look at this. But it doesn't mean that I said if you're, you know, above at 51% above the national average, that means you're this great district. I think you're 51%. I think, you know, I think we all should be striving to look at ways we can improve. And I don't know if the national average is the bar, but it's the only bar I got right now.
and you only know if you actually take the risk and release them to see if they're going to make a mistake.
I think at the very least, I think you should say you only know, I think there are people that can be released, and you only know if you're going to be open to assessing them accurately and looking into the background and making a recommendation for the officers or for the judicial officers. Yeah, at some point, the evidence can help. I don't know if it makes a big factor sometimes in a district like this where you have so many fives with 50 criminal arrests. I can't sit there and say, I'm not gonna go to anybody say that, you know, so I don't know. But generally speaking, and you all are somewhat different, that you have so many high risks. Generally, I could walk into a district and pinpoint. This is where we can target. It's very difficult in a district like this because your numbers are low on your low risk for me to come in and pinpoint something. I don't do it just to say it. I think you should reduce unnecessary detention, but if it's not there, I'm not going to say it.
So these are your U.S. Attorney's recommendations. U.S. attorneys in the District of Utah recommend release at lower rates than the national average for all Petra categories.
Can you go back to the release rates one more time? Right. Here's what I say about taking a chance. Generally speaking, and I don't know what the categories are, these are probably presumption cases. Generally speaking, people in this category are going to succeed higher than 80% of the time. Generally speaking, you don't have many twos and ones. We've already kind of looked at it. There's not a lot out there. You'll see when you see your numbers detained that there weren't a lot for us to look at. But generally speaking, those in category 3, they're going to be released. They're going to be successful 80% of the time. I can't make you say that everybody, you know, I can assure you 100% that they're not. But these are generally your presumption cases. These are generally those young kids that probably have unstable backgrounds, things like that.
I think here, because of how they're charging, I think that category is more illegal aliens who are bringing in drugs and things like that.
That's removed out of this. If you're illegal, these are all U.S. citizens. These are all U.S. citizen defendants. So if it's somebody that I would say take a look at, again, I don't say release them, I said take a look at this category of people, and maybe it takes the step of digging deeper to find what works and talk about it, it would be a category 3. So that may answer your question a little better about who are we looking at, who would I say. If it was anybody, it would probably be a category 3. Because I'm just not seeing a lot of 1s and 2s. I'm really not. I'm seeing a lot of 4s and 5s. And I think even 4s, they're a lot more difficult, but under the right circumstances, to get this successful 70% of the time. And here, the success across the country, that was back when we did the picture the first time. If I'm looking at the data there, that number is high. It's closer to 90% for 3s. And we're not talking about 5 or 10,000. We're talking, looking at hundreds of thousands of cases that's been released. So I think there's some cases, I think what we generally do is, that's where we come into where you say that criminal history is so bad, forget it. And I hope that kind of gives you an area what I would say. That's all I say.
So here you see your officer recommendations compared to your U.S. Attorney recommendations. And as Bill was talking about, that we try to identify areas for improvement. Some districts through DROP have found that their officers match exactly with their U.S. attorneys. That doesn't look like that's the case in Utah. Your officers are recommending a release higher than your U.S. attorneys overall.
In other words, they're not being used by the U.S. attorney. A lot of places we go, I've seen it where it's the exact same. And I've had a judge say, I don't need your stats to tell me that. I've seen this already every day. This is what they're bringing me every day. And generally speaking, there should be some difference because the U.S. attorney has so much information. So kind of, that's a gauge we use to see if the officers, you heard me talk about the courage of really doing the job. That's one of the gauges we look at.
So we talked about that you have a real low number of low-risk defendants. And so in Utah, between 2015 and 2016, you have 12 defendants in the low-risk categories that were detained. 3 category 1s, 9 category 2s. So again, it's category 3 where you would make more.
Do you have gross numbers for 1s and 2s? So we count this 12 out of 100 or 12 out of 5, 15?
We could pull that, sir. What we're more identifying, we could pull that. What we're more identifying is trying to say, well, hey, you detained in a district that has about 300 cases, 340, whatever, you detain 50 picture ones. You know, then we say, there may be an issue that we look at. You're not seeing it here because you're kind of seeing the cases that we kind of would expect, and that's why I kind of identified 3 and say, and these are all just U.S. citizens. You kind of say, here's where your number of your detentions are. But, I mean, we can get that for you. I can get that for you. That's no problem.
I'm still a little confused. Are you saying we only detain 20 people in 2 years?
No.
1 year,
1 year.
from 15 to 16.
And these are only U.S. citizen defendants and only defendants that they've done their pretrial background. So the numbers aren't everybody the U.S. attorney has charged and brought forward. There may be some cases where a report wasn't done, and we exclude those.
So on average, a pretrial defendant, it remains in pretrial detention on average 250 days. And the average rate of pretrial detention is $76 per day. So when we look at your category 1s and category 2s, the estimated total detention cost was $228,000 for those low-risk defendants.
This slide is, I don't know, a lot of people probably won't care. The reason that slide is in there is because the Department of Justice, we work together and they provide funding to assist in reducing unnecessary detention. And so they look at this. Yes?
Does that assume that they're not going to serve any jail time after their plea?
No, it just,
Is it cheaper on the front?
That's a great question. Is it cheaper on the front end? I can't say. What I can say is Department of Justice believes that the cost of detention on the front end was so high. So I get this money, it used to be called by the Office of Federal Detention Trustee, now it's called the Prison Operations Division. That the cost of detention is so high that they wanted us, that's how Pretrial started, was the Department of Justice, wasn't the AOs. And so they give me this money to kind of help reduce unnecessary detention.
Because they're going to have, in my court, unnecessary detention on the end.
Right. I know
What you call unnecessary detention, they're going to get it.
Right.
Because in the last 10 years, there are 606 felony defendants in my court. 598 pled guilty. 8 were not guilty. So that's 98.7%. They're going to spend time in jail. It's like the oil fram oil filter thing. You can pay me now or you can pay me later, but they're going to spend.
Can you explain in terms of the impact of a pretrial release in terms of how much time somebody does on the back end?
You know, I can't say for certain that, I'm not going to sit here and say that because somebody is released, they get a little sentence. Or
I'll say that.
I'll say that.
That may happen here. I don't know. I haven't studied.
They do well.
The AO has not necessarily studied and said because of that. I know there are studies that are out there that say if you are released pretrial, then you're likely to get a lower sentence. I have not replicated that study. I haven't at this point. It's part of me replicating the Kentucky study, but I haven't gotten to that point. But there are studies that say, yes, you will get a lower sentence. You will get a lower term of supervision. And in fact, right now with a lot of the, I'm sorry, sir.
Even on a minimum mandatory, that'll help them.
There are people that say, I'm not concerned about that. You know, a lot of the judges do. I mean, you have people that they have a lot of what we call alternative to incarceration courts out right now, where these folks come in and they're getting no sentence, or they're getting a reduction in sentence because they're proven that they can be released, that we can provide the services that work. The AO hasn't endorsed that, but I'm telling you, there are about 24, 25 across the country that do this on the front end.
Until last week, until this past week, after the new memo came out, Southern District of California had a diversion program where people would have minimum mandatories 10 years oftentimes. They were citizen defendants, they might qualify if they were young.
Mm-hmm.
So they would end up with 0 jail time.
Mm-hmm. Yeah, I know the CASA program, that's what it's called. And these programs, and I know that CASA program, and I know they have it in California Northern, they have it in New Jersey. They do, okay. A lot of them target higher risk defendants. So these same ones with 3s, 4s, these drug users, substance abusers in California and LA have shown that they can be released and it has some effect, and they do get lower sentences. I can't say for certain that's every case. I haven't studied it in that regard. And we haven't studied these courts to say how really effective they are.
Don't you agree that, I mean, one of the main goals of sentencing is to give the least sentence possible to still meet the goals of sentencing? And if you have someone who's been on pretrial release for a year and a half and has been employed and has been productive, and has been supporting his family or her family, and has, I mean, all of those things have a huge impact on the district judges when the case gets before them, and they say, look, you've proven, just like you said, that you can survive, you can do well in society, you're not at risk, you've proven yourself, you've earned this chance, I'm going to give it to you. And if you didn't get released on pretrial, it's just another person in a jumpsuit walking in chains, and it's very difficult, I would think, for a district judge to just know, how long do I need to give you to be the least restricted possible. I think it just makes it's just really a huge difference to our clients to have that chance. Now, I will not deny, some of them screw it up. And, the judges know that too. And then they get spanked a little harder when they show up. But gosh, it makes a difference for the ones that do well. It just really changes lives and families.
Oh, yeah, we're talking about it here. We're talking about it at the AO. And there's things that we want to take a look at, like how are they selected, things like that. Is this just random selection of certain types of people given or defendants given preferential treatment, things like that. Those are things we have to look at as we do. And these programs are different across the country. What I will say is that, again, the study shows that if you release, I'm going to keep it to just what the study shows. The numbers show that if you release pretrial, you're more likely to get a lower sentence. For whatever reason, whether it's an ATI program or in general. And I like to think that the reason is that we can provide those services. That's our name, pretrial services, not pretrial. And that's what the statute says that we should do. We provide those services to reasonably assure the appearance and the safety of the community. Well, while doing so, I think it has such a positive effect, and it can have an effect on the judicial officer's decision. Hey, I'm sorry.
So is our number of days of pretrial detention, are we in line with the national average of 250?
And I'd ask you, on average, here, I don't know if somebody here knows how long people stay in custody. I don't know offhand. Where I came from, I come from the rocket docket. Virginia Eastern is called rocket docket because you're done in 6 months, doesn't matter who you are. Even when the governor came through, it was 6 months, done. It doesn't matter. Michael Vick, done 6 months. It doesn't matter who you are. But there are some districts that double that in terms of, there are people who've been on pretrial release for 3.5, 4 years in the federal system. Still. That I think is somewhat, I can't say why, but I find that hard to believe, but it's the truth.
And I was just going to add that the Laura and John Arnold Foundation, the study that I referenced at the very beginning, they had another component of the study that looked at the effects of pretrial detention on sentencing. And their results were that you were more likely to be sentenced to a custody sentence, and then it would be a longer sentence. So you can find that online if you wanted to find a study. The average daily rate of pretrial supervision for a pretrial defendant is $9 a day. So I said a minute ago that the cost, based on the average rate of detaining your low-risk defendants, was $228,000. If they'd been released, the average cost would have been about $14,000. So here we're looking at your supervision outcomes. And I've kind of broken it down to make it a little easier to read. Oh.
Here's your question about the picture revocations. I think somebody asked, did we have any background about picture?
Oh, okay.
Excuse me, before you go, didn't you ask about picture revocations? Take a look. We do that. I don't want you to go. Look. We
supervision outcomes. Your failure to appear rate, it showed a 0 for the time period that we looked at, rearrest rate 1.5, and technical violations of 5.3. So I don't have this for failure to appear because it was 0, so it was 0 across the board. But here's your revocation for technical violations. Utah compared to the nation. You can look at that by Petra category.
So that might even suggest overconditioning the ones and twos.
I'm sorry.
You know,
Maybe
not necessarily, so you have to look at it.
What we looked at before was, is there an increase? You're seeing an increase. But when you look at these numbers, I'm not going to, our revocation rates are so low, that's kind of, your revocation rates are low as well. So it may not be, you know, that's what I said about digging. You have to look and keep digging and digging into the weeds. But here, I would say 2.6%.
Why are we able to avoid technical violations on our force supplies better than the nation?
Don't release many of them.
Right. I'd probably say the persons you release here are the perfect guy. Somehow there's something that they may be, how they're being released and what they're being released into.
Judge, we also have options that, and resources that maybe other districts don't have or don't utilize. Some of our EVP things, some of the other things that, MRT, some of the things that maybe others don't use. Jedi mind trips. That's it.
And here you can see your new arrest rates broken down by picture category.
There's that category 3 again. I don't know, they're reporting no arrest for a category 3 person, but you're releasing them at about 46%. And I say category 5 is because not many are getting out. So that again, that's the perfect person. But I would bet that the court has taken a chance on some category 4. Probably could take more. But if I looked at anything, it'd be that category 3.
So this is a different report. This is a 1291, and this looks at new charges by picture category. And so overall for 2015 to 2016, defendants incurred 10 new charges. Your total supervision population on the 1244 was 331 defendants, and there were 7 defendants. There were 10 charges, but that was 7 defendants that incurred new charges, and there you can see what those charges look like.
So here, go back, Sarah. So I want to show you something.
Right.
Here's where you see what the officers reported. Here's what we could pull along with the FBI arrest file. So you have to do what we call data quality. There can be some issue. Go back.
Do the 1091.
1291. So if you look at the category 3s, actually did have charge. They had a drug, a financial, a public order, which is probably like loitering, and 2 for violence.
The highest number fell as traffic and DWI cases. That's consistent with the rest of the nation.
Okay, just stop here for a minute. Can you just tell us that of those released, we get great supervision or great compliance because it's, what is it, 2%?
Overall, I would say this. This tells you that other people who are released, you have good supervision. And the majority of people who are released are overwhelmingly compliant, up towards 90%. It doesn't tell me, I can't sit here, and even those who are arrested, yes, the majority of people who are rearrested are for traffic offenses. Yes.
Do you have national data on the number of individuals supervised by each pretrial officer and whether there's a correlation there with technical violations?
No, that's an absolutely great question.
Did you work for the union or what?
Yes, the
Job security.
the district has it, and the chief can get access to that.
I mean, we saw graphics with the number of technical violations much higher in this district. But do you have any idea if there's more individuals supervised or fewer individuals supervised?
It would, again, it would be something that the chief would say. I mean, you could bring that concern to the chief, and the chief will make that decision. The data is pretty much there. It's not for me to pinpoint to his officers and say, hey, this guy's bad, because I'm not here with that officer every day, and I don't know the circumstances of that report or case. So we generally won't do that unless there's an issue where the chief has asked us to.
So say you were at like a casino, for example, and you had to decide whether you were going to lay your money down and take a bet. Like, let's say on blackjack, which I think the odds are like 75% you're going to lose, and you still lay your money down, right? So what you're telling us is it's a pretty good bet here with these super low percentages of non-compliance, that we should be taking more risks and letting more people out.
She's the federal defender.
Yeah. And we should really reevaluate if we're doing everything we can to ensure that people who are presumed innocent are allowed to be released.
I've reversed the order, but I would say that you could, yes, I'm saying that from this information, some reevaluation can be done, probably should be done, and then that if you, based on that reevaluation, you're probably going to find a few people that can't be released. Can't say how many, not going to tell you to do it. But I think based on what we see today, if you would say betting odds, I'll put my money on the table. Because
But Bill, aren't you also saying, excuse me,
No, no, sir.
aren't you also saying that, as I looked at the numbers, that our release rates are just a tad higher than the national average? 46 versus 45, versus 44 versus 45, whatever it was.
it depends on how you look at it. You actually, when you look at U.S. citizen, you're slightly under.
Okay, but my point is, you've also said that we have a much more violent
That's exactly right.
population. So we have a bunch of candy-ass judges here who are releasing people who are violent and dangerous and based on those numbers, because our numbers are very comparable, and yet we've got a much more serious population that we're dealing with.
I agree.
Is that a fair reading, as opposed to what Kathy was saying?
I think it's both. I think I love this. This is what I want. I actually love this. I think it's a little bit of both. You were right. I said it earlier that it's going to be very difficult in this district because you have such high-risk people. And so naturally, you tend to say, I'm going to lean more towards, look, I'm looking at these high risks that present. I know, I get it. Naturally, that's what you're going to lean to. But when you start to look at some of the data that says, hey, overall, these people are doing a good job. Overall, I trust these officers. We're showing these officers are doing their job timely, so we're not worried about whether they miss a beat on something. And if somebody does something, they're going to be on it. I think you could take a look at it. All I'm asking for is to reevaluate everything. If you don't see that anything is there, it's not there.
But in category 5, sir, the worst category, there's no new arrests according to your data, right? So we can assume that we can take a little bit of risk and release a few more people, and it's not going to change that much.
I would say that there's some people that release high-risk defendants at a very high rate and don't find that they're really high, that they have high success rate. There are districts who do that. And I think that's what I'm saying. You can take a look, but I'm clearly not saying just go in. I know what Catherine did that. So just because I'm a bad man, that I'm going to throw my hand. No, Judge, I'm not saying that. I'm not saying that at all. I want us to have this discussion start, to take a look, get deeper into the numbers. What are these cases? And are these cases, what does that picture 3 look like? What type of cases? Is there a way? What are some of the characteristics that we're seeing about this picture 3? Do they have stable homes? Do they have this? Do we have the ability to put housing and shelter for those that don't, or place them in treatment options for those that don't? That's what we'll kind of, when I say reevaluate. And it may be that at the end you say, yes, we could do something, or maybe at the end you say, hey, you know what, we've done all we can do.
Just one final comment, because good friend Kathy used the analogy of putting the money on the blackjack table. The difference in my mind is that if you lose your $10 on the blackjack table, you've lost $10. Here we're dealing with real people's lives. And, you know, it may be, even at category 5, it's a relatively low risk, what, 35% or whatever it was. But if we make a mistake as judicial officers, the ramifications can be catastrophic. And they don't say, well, what was the recommendation of the pretrial service officer, or what did that federal defender want, or they want to know who's the dumb judge to let this guy out when he has this kind of a criminal history and so forth. So the reality is, the risk may be low, but the consequences can be very, very high.
I think that's why the statute said reasonably assured, because I think I can tell you that what the response would be from me, that if I know we've looked at this, I know as a judicial officer that I've weighed the factors on the 3142. I know I've looked at this pretrial report, and I know that I've come to the decision that I'm going to come to. Yeah, I can reasonably assure. You know, that's all we can do. We can't, there is not one person in this room that's 100% certain.
But aren't you just shifting the risk off of you onto people that are deserving of the presumption of innocence? I mean, you're just shifting the risk and saying, well, in order to avoid that risk that I'm going to be judged, or they're going to come after me, I'm going to make all these people sit in jail that maybe shouldn't sit in jail.
Here's the fallacy of your argument, Ms. Nestor. There's a little bit of criminal history here. It's not just saying, let's shift it to Kathy. Let's shift it to somebody who's has a criminal history longer than my 37-inch sleeve length, that has an absolute history of violent behavior over many years. If I'm shifting the risk, it's a knowing, conscious, carefully weighed shifting. It's not that I'm afraid of the ramifications of me personally. It's not the fact they said, who's that dumb judge? It's the fact that somebody out there has been victimized. That's the concern. It's not that my reputation's been hurt, but somebody else has been hurt in ways that may never be fixable. So that's the risk I'm concerned about.
Yeah, but you're using the term violent right from the beginning, and you never let anybody out who's violent. So those are the people that are going to be held no matter what. What we're talking about here is giving our clients a chance who are really not these violent people. Maybe they're tweakers, maybe they're somebody else. Let's give them a chance. They're not out the ones holding up the gas station. They're not the ones pointing guns at people. Let's give these guys a chance.
Some of them, absolutely.
And to follow up on that, to what extent does your office differentiate within Category 5 or within Category 4? I think there ought to be some tools to differentiate between the individuals that Judge Warner is talking about and maybe the individuals that Kathy and Randy are talking about. Just to, with a broad brush, say they're Category 5 because maybe they have 30 arrests historically. That could present a risk, but it may not be the same risk as 3 arrests for aggravated robbery or rape or whatever they might be.
Yeah, that's a good question. That's why I asked Dr. Lorkep to go back and look at all predictions, and why I said at the very beginning that one of the things we're doing in this new revalidation I wanted was to be able to hopefully predict for violence. To be able to say, violence, here's a person in this category now, we can say for certainty what your probability of violence may be. It's not saying 100% that me as a 5 is going to do this, but at least add that element, because I know what the fear is. And if we can research it and we can take a look, but even then, give you 100% certainty, you still would have to buy to the fact that this is done over looking at thousands and hundreds of thousands of defendants to come up with these probabilities. But I have asked, let's go back and take a look at everything, because I wasn't here when Pretrial started, but I'm here now, and I'm hearing all these concerns from both sides. And it may be that we say again that violence is such a rare event, it's hard to predict. I get it. We may say, oh, it's not going to happen, because it rarely ever happens necessarily. We look at the proportions of people that are on release. It doesn't happen a lot.
But what about looking at studies that the U.S. Sentencing Commission has done of offenders who've been sentenced? For example, an offender who has 0 criminal history points recidivates at a much lower rate than somebody's in category 1, but has 1 criminal history point. And both of them actually are much more of a risk than someone who has 0 prior contacts with law enforcement. So I think you could maybe use some mechanism or some study to do a similar analysis within category 5 or within category 4.
And that could be a good point. I don't know if it will be something necessarily in the revalidation, because again, once you start doing that, then I have to shift that burden to them to get that. And I don't know if anybody has that time to be able, it's not the post-conviction risk assessment tool, and that's what, and we have been clear that we don't want to use the picture ever for sentencing purpose, but I know that's not what you were saying, but I don't want to shift to that either. Yeah. I took over your presentation, and I told y'all I was going to try to sit down. I did it anyway. So, you all, I was worried at first. I was like, nobody's going to come back. Nobody's going to come. Jesus, dude, was it that bad? I was sweating in here. You saw me up. It's like, oh my God. And once we brought the data out, man, this room lit up. And I love. Listen, I've had everything. I've been yelled at. I've been walked out on. I've had people throw stuff at me. I've had it all in my conversation. I never get offended or take anything personal. I love these types of debates because this is what I said in the beginning. Just having these conversations lets each other know what our own mission, our own position is, and where we stand. And it opens up the door for future collaborative efforts. I wasn't here to put a picture and shove it down your throat. And I just wanted us to have a talk, a discussion about it. So with that being said, unless there's anything else of us, I'll turn it over to Jeff or Judge Nuffer, so whoever wants it. But we're done here as far as the drop program. Again, this was a simulated version, kind of smaller, kind of shrunk down version, but you all were an awesome audience. So I thank you. I applaud you for your questions. Feel free to come up. I'll give you my card if you want to ask questions in more detail.
So, Bill, I want to thank you for being here. Jeff wants to thank you for being here. I'm going to let you stand up. We look forward to tomorrow. Judge Weinberg is here with us, who will be presenting to the judges and pretrial officers tomorrow morning in 5215, right? And then who is coming to present with you?
Connie Smith, the Chief Probation Officer from Western Washington.
Okay, all right.
That is 74% legal.
All right. So, orders, right?